Welcome. This is the 2019 edition of the Civil Procedure and Remedies slideshow and audio files so that you can review and study the essential material that's important in understanding how civil suits get filed and where they get filed and what the rules are, both from the standpoint of the plaintiff's options as well as the defendant's options as that case proceeds from the beginning to the ultimate trial, and then to go further with respect to preserving issues for appeal and the like. So we're going to start with subject matter jurisdiction, personal jurisdiction, and venue, which is what is section 1 on this review. Subject matter jurisdiction, personal jurisdiction, and venue are essential in order for a case to be filed. There are various tests for subject matter jurisdiction, which we call the power of the court to hear the controversy, personal jurisdiction, which is the power to bind the defendant to that judgment, and venue, which is based on where a substantial part of the events giving rise to that cause of action occur, or wherever the defendant has established the requisite contacts, ties, and relations. And so you have alternative tests for venue. Oftentimes, in doing this analysis as to what court has the proper subject matter jurisdiction, personal jurisdiction, and venue, you will come to the conclusion that the matter may be filed in federal court or state court, federal courts of a specific jurisdiction, state courts of a specific jurisdiction, or that can actually be filed in both federal and state courts, and there are multiple potential geographic locations where you are able to establish all three of the essential ingredients for filing a suit: subject matter jurisdiction, personal jurisdiction, and venue. And so then you have your choice as to where you think it would be best to proceed with that suit and move forward based on your client's likelihood of success. At the same point, once that action is filed, the defendant has various choices as well, and so the idea is that both parties at some point, or both entities, the plaintiff and the defendant, will attempt to use the process to their tactical advantage. But at the beginning of this, as we think about subject matter jurisdiction, personal, and venue, all three must be established to properly maintain a suit. So what is subject matter jurisdiction? Subject matter jurisdiction is the power of the court over the controversy. Without it, any judgment the court renders is void. The power to hear controversies, whether it's a federal or state court, comes from somewhere. The power to hear controversies derives from the Constitution and various federal and state statutes. Because it goes fundamentally to the court's ability to properly adjudicate the dispute, the rule is that the lack of subject matter jurisdiction can be raised by anyone at any time. Anyone at any time can raise the question about the lack of subject matter jurisdiction, the court's power to adjudicate the dispute. Therefore, it's essential that in making this analysis that you are cautious and have a logical, rational basis for why you're choosing that court. It goes to the court's power to hear the controversy, and if you choose a court that is without the power to hear it, that judgment, even if successful, can be voided upon someone arguing that the court lacked the subject matter jurisdiction to entertain that case. Subject matter jurisdiction, it breaks down into two categories. When we're looking at whether a federal statute or state violation can be brought in federal or state court, we talk about those statutes or the basis to bring those suits as either conferring concurrent or exclusive jurisdiction. Concurrent jurisdiction, from the standpoint of subject matter jurisdiction, means that the action can be brought in either state or federal court. Both bodies of courts have the power to hear that controversy. This is compared to exclusive jurisdiction. Exclusive jurisdiction means the action can only be brought in either state or federal courts, and therefore if you would bring a statute that confers exclusive jurisdiction in federal court to a state court, then that state court is without the ability to hear that controversy. It lacks subject matter jurisdiction, and it should be dismissed. A couple of common examples of exclusive jurisdiction. Federal courts, for instance, have exclusive jurisdiction over bankruptcy proceedings. There's a separate bankruptcy court, actually. They also have exclusive jurisdiction over admiralty claims. Those are only within the power of the federal courts. State courts generally have exclusive jurisdiction over divorce actions. The federal court has neither the time or the inclination to hear those cases and feel that the state courts are best suited with their specific resources to be able to resolve matters of state law which deals with these divorce cases. And so they, through a principle called abstention, stay out of divorce actions and leave that to within the exclusive jurisdiction of the state courts. Concurrent jurisdiction means the action can be brought in either state or federal courts, where exclusive jurisdiction means the action can only be brought in one or the other. Federal courts have subject matter jurisdiction over all civil actions arising under the Constitution or violations of federal law and treaties of the United States, regardless of the amount in controversy. So as long as the plaintiff has an injury, as long as they have some damage, then regardless of the amount of those damages, those matters can be brought in federal court on violations of the federal law or the federal statutes, and it doesn't make a difference how much those damages are. On the other hand, when subject matter jurisdiction is predicated on diversity jurisdiction, then there's a couple of important tests to determine whether the court has the ability to hear the case. But the first principal one that you start to think about is, unlike federal questions and constitutional issues, the damages must be likely to exceed $75,000. Diversity suits are state law suits that, because of their size, their dollar amount, and the citizenship of the parties, get to go to federal court. The rule is that there must be complete diversity of citizenship between the defendant and the plaintiff, and the claim is likely to exceed $75,000. When we talk about diversity of citizenship, what we're talking about is the plaintiff and defendant's domicile. A domicile is the true, fixed, and permanent place of residence, the place you intend to return whenever you're away. And so that becomes your domicile. No plaintiff state can match any defendant state in order to have complete diversity, and that claim must be reasonably likely to exceed $75,000. For the purposes of diversity jurisdiction, corporations are considered citizens of both their state of incorporation and their principal place of business. Their nerve center, where the brains of the operation reside and make those management decisions, that is in fact a corporation's principal place of business. When we're looking at federal question jurisdiction, as long as there is a violation of the federal statute or the Constitution or the laws of the treaties of the United States, then the federal court can hear that matter regardless of the amount in controversy. Thus, there's no reason to meet the $75,000 amount in controversy as there is in diversity jurisdiction cases. That figure only applies to diversity jurisdiction. State court jurisdiction. State court generally will hear all violations of state law, some violations of federal law for which there is concurrent jurisdiction, and some controversies are generally reserved for state court resolution, such as divorce cases and other family law issues. Those matters vest and rest with the sound authority of the state court to entertain those proceedings. When we're examining questions of subject matter jurisdiction, ask by what authority does the federal or state court have the power to hear the case? Is it based on a violation of the Constitution, a federal or state statute, or is there some lesser authority or likelihood as well for why the court can hear that case? The issues of subject matter jurisdiction can be raised by anyone at any time. And the court must hear the matter if it has subject matter jurisdiction, because without it, any judgment the court renders is void. Once a federal court has the power to hear a case based on the likelihood of a violation of a federal statute or the constitutional issue, another principle exists called supplemental jurisdiction. Supplemental jurisdiction provides the federal court the ability to hear other claims that arise from the same nucleus of operative facts as the principal claim that is asserted in federal court that has a valid basis to be there. The idea is that it's in the best interest of all, as well as the court, the convenience of the parties, to resolve all controversies that arise from a single set of facts or circumstances. Through the operation of supplemental jurisdiction, that confers upon the federal court the ability to hear related claims as a claim that has a valid basis to be in federal court. Supplemental jurisdiction replaces the concepts of ancillary and pendant jurisdiction. Courts, in essence, should resolve the entire controversy at one time. By doing so, it avoids issues later on down the road of res judicata and collateral estoppel, which exist in order to prevent litigation over and over and over again once a court has resolved a matter fully, fairly, and with finality. It is rare that the court will revisit the examination of that issue, and that's based on, in part, res judicata and collateral estoppel. But just because the plaintiff chooses to file suit in a given state doesn't mean that's where the case is going to stay. Removal jurisdiction provides the defendant the right to remove an action from state court to federal court if the action could have otherwise been brought in federal court in the first instance, unless the basis for removal is diversity jurisdiction, and in that instance, the defendant cannot be from the state where the suit was entered. Subject matter jurisdiction goes to the court's core ability to entertain that case. To the extent it doesn't have subject matter jurisdiction, any judgment it renders is void, and it can be raised by anyone at any time that the court lacked subject matter jurisdiction. Personal jurisdiction, the second of our three important requirements for the ability to file suit. Personal jurisdiction is the power to bind the defendant to any judgment it renders. Personal jurisdiction is waivable, and thus can be conferred by consent. The defendant confers personal jurisdiction upon the court by failing to raise it in its first offensive move. It's a use it or lose it argument, and if you don't raise it in the first offensive move, either by way of your answer or as an affirmative defense within your answer or by way of a motion to dismiss, then you have waived your rights to contest personal jurisdiction. Unlike subject matter jurisdiction, it is waivable. Personal jurisdiction is obtained by establishing the defendant's minimum contacts within the jurisdiction such that the court's exercise of jurisdiction is reasonable. Was it foreseeable that the defendant could expect being hailed into court in that jurisdiction based on their activities, their contacts, their ties, and their relations in that forum. Was their activity within the forum systematic and continuous? Remember the important cases, International Shoe, Worldwide Volkswagen. The cases actually looked at the defendant's level of activity within that forum such that it was then reasonable to make them come in and defend. Remember a few important things about personal jurisdiction. The entry of a product into the stream of commerce in and of itself is not a sufficient basis for the exercise of personal jurisdiction. The focus instead is upon the activity and contacts of the defendant with that jurisdiction. Do the defendants avail themselves of the benefits of doing business in that jurisdiction? Do the defendants direct their activities at that jurisdiction? Do the defendants direct their products at that forum with the expectation that they could be consumed or used there? Those are the type of activities, not simply dropping your product into the stream of commerce and you not taking any action to have it over there. Personal jurisdiction can either be obtained through what we call general jurisdiction or specific jurisdiction. General jurisdiction is where the defendant is essentially at home because they have so many contacts, ties, and relations there. And after the Mercedes-Benz case and the Dunlop tire case, the court has narrowed the scope of general jurisdiction. So general jurisdiction is because those contacts, ties, and relations are so extensive that the defendant is considered, quote, essentially at home, close quotes. That's going to be one or two places as you think about where a corporation would be essentially at home or where an individual would. With respect to specific jurisdiction, which is the alternative basis for personal jurisdiction, specific jurisdiction is obtained when the defendant's contacts, ties, and relations in that forum give rise to the cause of action for which you're now suing. In that event, it's fair that those minimum contacts be used because those are specifically the contacts that gave rise to the cause of action. It's not unreasonable for the defendant then to have to account for those activities since they gave rise to the injury in that jurisdiction. Personal jurisdiction, we also saw in California versus Berman, which reiterated earlier teachings, that an individual who is voluntarily present and personally served with process within that state is subject to that state's court's exercise of personal jurisdiction. The defendant individual who's personally served is subject to the court's exercise of personal jurisdiction, but don't mistake this for a corporation's agent who might be served. We saw that in International Shoe. The fact is that a corporation is going to be based on either general or specific jurisdiction, as we just discussed. In rem jurisdiction, also can replace personal jurisdiction, but in an in rem jurisdiction situation, you're arguing that the property is the focus of the dispute, and therefore the court is going to determine title to the property, since then it becomes what we call an in rem proceeding, not an in personam proceeding. So the in rem proceeding is the court's exercise of jurisdiction over the property when the property is the focus of the dispute. An adverse possession claim is the prime example of a type of in rem proceeding. After Schaefer versus Heitner, there's no quasi in rem jurisdiction without the required minimum contacts. Lastly, again, remember now there's been significant changes in the context of personal jurisdiction. General jurisdiction has been narrowed to where the defendant is essentially at home. Even corporations like Microsoft and Apple cannot be sued across the entirety of the United States based on general jurisdiction. They can, however, be sued across the entirety of the United States if the cause of action arises from their contacts in the state. And on that basis, we can exercise specific jurisdiction over them for the purposes of obtaining personal jurisdiction over those entities. Lastly, of the big three, we're talking about obtaining venue. Venue is the most mechanical of these three concepts, and venue refers to the proper judicial district in which to bring the action. A lot of times we tend to look at and think about where the witnesses are, where the evidence is physically located. Venue is a waivable defense, so if it's not asserted in the first move, it is lost. But there are specific tests for venue that go beyond the location of the witnesses and things like that, which allow a court to transfer or even dismiss a case. The specific test for venue, when you're talking about the initial choice of the forum, in federal court, the test for venue considers where the cause of action arose. Where did a substantial part of the events giving rise to the cause of action take place? And that can be multiple places. Or where the defendant resides. Where has the defendant established those requisite contacts, ties, and relations? So there's two different ways to look at it depending on it, but this will again start to narrow the field significantly. In state court, if your choice is state court as to where this matter might be filed, the test for state court venue includes the location of the plaintiff, the location of the defendant, and where a substantial part of the events giving rise to the cause of action occur. So we have a little more latitude with respect to state court venue. Lastly, for venue, when we're talking about venue, oftentimes a party may seek to transfer a case based on this being a less convenient venue than others, or even to move to dismiss it based on what we call forum nonconvenience. So a party can seek to transfer on a forum nonconvenience, or ultimately even dismiss on a forum nonconvenience, as we saw in Piper versus Reno. The question becomes, when reviewing venue for either transfer or dismissal purposes, is there a more convenient place to try the case? And this specifically looks at the factors about the location of the evidence, the location of the witnesses, what's the forum's interest in resolving the dispute, and what's the party's desire to have the forum resolve the dispute where we presently are. Those factors then really suggest to the court that if we're going to go forward with this case and try it, then we really should be thinking about convenience and the ability of the court to actually properly bring the proper parties and gather the evidence and ultimately resolve the dispute. And so oftentimes we will see people ask to either transfer a case from one federal court to another, or ultimately dismiss a case because there is no federal court which is sufficiently convenient based on the location of the witnesses and the evidence and the like for that case to be heard within the United States. And that's precisely what happened in Piper versus Reno. In summary, as you think about these three, it really takes an analysis of whether we have subject matter jurisdiction, personal jurisdiction, and venue, what the various choices are for both federal and state cases, what our injuries are with respect to damages and the like, and where we think we have the best chance of establishing the existence of all three of these and proceeding as rapidly as we can to judgment. The fact is that while the plaintiff gets the initial choice in establishing subject matter jurisdiction, personal, and venue as to where to file their complaint, it is far from the last word on where the appropriate forum is, because the defendant, either through a transfer on a forum nonconvenience, removal jurisdiction, which exists when the defendant chooses to take a state case from state court to federal court because it could have otherwise been brought there in the first place, and now start to be able to, while cognizant of plaintiff's choices, recognize that there may
This is Section 2. In Section 2, we'll be discussing questions about the complaint and relief, parties, damages, and injunctions. Question 2 is about, now that we've decided where the case can be filed, what does the case actually look like? What are we asking for relief from the court? And what is the complaint? What is the document that we initially file in court? What does that look like? And how do we file that in an appropriate fashion so that we can get the relief that we're seeking from the court? Under Rule 8, complaints must contain clear and concise statements of fact, not conclusions of law. What that means for all intents and purposes is that both in Massachusetts and under the federal rules, we operate under a notice pleading system. And that means simply that we should be putting the defendant on notice as to what took place that gives rise to this cause of action. We don't want a lot of legalese. We don't want a lot of conclusions of law in there. State the facts in a clear and concise manner that would justify awarding relief in this case. Under Rule 38, if you want a jury trial under the federal system, you have to demand it. And you should demand it. Generally, the better practice is to demand it in a complaint, because then you won't forget to file a document a short time later that would allow you to request a jury trial. So the better course of action is in a complaint when we file it is to both plead in clear and concise fashion our claims that give rise to this cause of action, as well as request a jury trial on all issues that are so triable. Under Rules 19, 20, and 21, it's important that the appropriate parties be named in the complaint. That the plaintiff, if it is in fact a corporation, is named appropriately. That we know who the defendants are and what their state of incorporation is and where they're to be located. A corporation that's formal name is Penn Transportation, Inc. should be named as Penn Transportation, Inc., not Penn Transportation. It's important that when one looks at the complaint, one knows not only who the plaintiff is and who the defendant is, but who all the other parties are that may be involved in this dispute. And it's important that we have some vehicle for bringing them before the court. If an important party, what the law ultimately calls an indispensable party, isn't named in the cause of action, then that complaint can in fact be dismissed. So it's important that the appropriate parties are in fact found in the complaint and properly described in the complaint. Sometimes that there's been causes of action where a large number of people have been injured as a result of common questions of fact or law. If you think about it, a lot of time in the newspapers you'll see notices in the back, have you been injured as a result of the use of this product, or have you bought defective roof shingles? Some of the larger cases have been personal injury cases in the last few years. The Agent Orange cases, where a number of servicemen have been injured as a result of exposure to Agent Orange. A number of the tobacco cases have been brought as what's known class action suits. And what that means is that we've got a whole bunch of people that have been injured as a result of common questions of either law or fact. Usually it's a combination of the two. And we allow these groups to sue collectively in order to allow the court to spare some resources in resolving these disputes. And those are called class actions. In a class action case, we need to know that the plaintiff, whoever the named plaintiff is, can fairly and typically represent the injury of the class. That the injury that that person suffered has a very similar relationship to other members of the class. We also know from cases along the lines of Phillips versus Schutz and the like, that whatever law we ultimately use to resolve that controversy, it has to bear a reasonable relationship with the controversy itself. Because remember, anytime we have a class action, in all likelihood, we're going to have representatives or class members from all over the United States and elsewhere. And so whose law is used to resolve that controversy becomes a constitutional question. And the decisions have been that it must bear a reasonable relationship to the controversy itself. We also have questions, and we'll talk about later in the last section, about choice of law when we're trying to resolve this question on whose law applies. Also, when we're looking at class actions, we can have attorney's fees that are awarded under class action suits, either under a private attorney general's theory, a substantial benefit theory, or a common fund theory. And all those theories really mean is that somehow the plaintiff's attorneys should be compensated for their efforts in order to achieve satisfactory results on behalf of the class group. An interpleader is another form of complaint that's frequently filed under Rule 22, and that is where if someone is a stakeholder holding certain funds or property of some sort that belongs to others, and you can file an interpleader under Rule 22, which tells the court, listen, I no longer own or control these funds, you should, and you should resolve it and give it to the following people, or at least decide who among the following people should receive these funds. An interpleader action, where a stakeholder is holding certain things but wants to have the court adjudicate the rights to those things. Damages are part of the complaint. Damages is where the prayer for relief comes in. The concept in a civil case is to try and make the plaintiff whole, to somehow compensate the plaintiff for whatever damages he or she has suffered, to put them back in the same position they would have been but for this controversy. Under damages, we have general damages, special damages, and punitive damages. General and special damages are designed to compensate the plaintiff for their out-of-pocket costs or their loss of benefits, society, and companionship that they may have lost. And punitive damages, which are rarely awarded, but punitive damages in some actions are designed to punish the offensive behavior that the defendant may have engaged in. Sometimes you see punitive damage awards in wrongful death cases and the like. Not every statute confers punitive damage, and it really is based on a desire for the court or the jury to punish the defendant's behavior in order to deter future conduct of that sort. Another type of relief that's frequently sought in civil cases is what's known as injunctive relief. Injunctive relief can come in three different stages of a case. The early stage, if one was sought injunctive relief, is what's known as a TRO, a temporary restraining order. Temporary restraining orders can be either mandatory or prohibitory, either prohibiting certain actions or forcing certain actions of the defendant. The next stage in the life of an injunction is a preliminary injunction. Preliminary injunction is usually issued after some form of evidentiary hearing, still early on in the process, not as early as a TRO, which TROs can be issued even without notice to the defendant if the situation is so serious. But a preliminary injunction, usually the defendant has come into some form of evidentiary hearing, made their case, and then the court has determined whether the action is serious enough that while the case proceeds, some form of either mandatory or prohibitory injunction should be in effect. And the last stage in the life of an injunction is what's called a permanent injunction. And a permanent injunction forces the defendant to either do or prohibits them from doing something forever. It can only be issued after a full hearing on the case. And all of these injunctions are discretionary. And what that means is that there's never any entitlement to an equitable measure of this sort, an injunction requiring or prohibiting certain action. The most famous case in this line of cases is Weinberger versus Romero-Barcelo, where the plaintiff had put forward a very, very strong case showing that they would be entitled to relief, and the court said, notwithstanding all of that, there's never an absolute entitlement to an injunction. But in order to make a showing for an injunction, you need to show 5 things. 1, no adequate remedy at law. What that means is that money damages will not make you whole. No adequate remedy at law. 2, you must show that there's an immediate and irreparable injury that you're suffering. It means I can't wait till the end of this case to get what I'm seeking. An immediate and irreparable injury is occurring as we wait here for the adjudication of this case. 3, likelihood of success on the merits. How likely is it that the plaintiff will succeed? The more likely the plaintiff is to succeed, the more likely they should be in receiving their grant of injunctive relief. The less likely they are to succeed, the less likely they should get, as a preliminary matter, any form of injunctive relief. 4, the court has to balance the harms. And these are the competing harms. The harms to the party if the injunction is not granted, or the harm to the party that the injunction is granted against. Balance the harms, or the competing harms have to be considered. 5, the last question that comes up is, what if any public policy considerations are at stake here? Are there issues of free speech? Are there issues of national defense, as there were in Weinberger versus Romero-Barcelo? What are the public policy considerations involved in resolving this controversy? And we ask, when we make that assessment as to these 5, what would equity and conscience do with respect to this case? It is always discretionary. A judge makes the decision, no jury is involved, and the court tries to do what is fair and what is just in addressing these 5 issues and deciding whether to grant a TRO, temporary restraining order, preliminary injunction, or a permanent injunction. In cases where both monetary relief and injunctive relief are heard at the same time, then those actions should be combined so as to avoid any issues of collateral estoppel and res judicata. Collateral estoppel is where a court has at one time resolved issues in a case and is not going to look at those issues again because they've been fully, fairly, and finally adjudicated. Res judicata is where a claim itself has been adjudicated. When a claim has been fully, fairly, and finally adjudicated, then res judicata requires that the court use the prior adjudication in order to avoid conflicting results. Res judicata and collateral estoppel are both matters that fall within what's known as stare decisis. The court has resolved these controversies at one point in time and is not going to resolve them or look at those issues again except on appeal. Collateral estoppel is issue preclusion, res judicata is claim preclusion, and in order to avoid the operation of the two, or either one, when we have matters that involve both monetary relief and claims request for injunction, then both of those actions should be heard at the same time in order to resolve or avoid issues of collateral estoppel and res judicata. In essence, to make sure that we don't have conflicting results when we have claims that involve both equity and law. This ends section 2. This is section 3. Section 3 of our civil procedure review deals with service and the initial responses of a defendant. Matters involving due process, motions to dismiss, various defenses the defendant can file, Rule 11 obligations on behalf of both the plaintiff and the defendant's attorney, counterclaims and cross-claims. Due process requires notice and an opportunity to be heard before a defendant can be deprived of various properties. Service under Rule 4 of the Rules of Civil Procedure requires a defendant to be notified, procedurally properly notified, so that they can come in if they choose and have an opportunity to defend the action. If we look at Rule 4, either under the federal rules or the Massachusetts rules, we would see how service is affected, but it's not generally required that service be in hand, the summons in hand, physically in hand to the defendant, only notice reasonably calculated to apprise the defendant as to what's going on. And that might mean a mailing to the last known address, either by certified mail or others. But the point to remember here is notice reasonably calculated under the circumstances to apprise the defendant as to what's going on. In the event the defendant, having received proper notice, chooses not to answer the complaint, then a default judgment issues. In essence, what the court is saying is that the defendant, having received notice, doesn't dispute the allegations found in the plaintiff's complaint, and therefore summary judgment, or not summary judgment, but judgment should in fact issue on the case. Defendant may choose to respond in some fashion. There are two principal ways the defendant can respond. Either by filing a motion to dismiss under Rule 12 for various reasons, improper venue, improper service, insufficiency of notice. Quite frequently, defendants will file motions for failure to state a cause of action under Rule 12b-6, saying in essence that, well, I see everything in your complaint, but it doesn't rise to a level of a violation of law. Therefore, the complaint should be dismissed. Whatever motions, if one looks at Rule 12, one can see that there are a number of motions there that can be brought for reasons to dismiss. Generally, all of those defenses should be preserved and raised within the same motion. Assuming a defendant doesn't file a motion to dismiss and chooses to answer directly, or assuming a motion to dismiss is filed and denied by the court, the next thing that is generally done is an answer is filed in the case. And an answer is the defendant's response to the plaintiff's allegations in the complaint. And what that means is, in a clear and concise, straightforward way, the defendant responds to the plaintiff's complaint, either admitting or denying the allegations that are in there. There will also be filed at this time various affirmative defenses within the answer. And an affirmative defense under Rule 8c is required to be raised by a defendant. And what that in essence means is, I've read the complaint, it's all there, but for various reasons, you still lose. For instance, one of the most common affirmative defenses is the statute of limitations defense. That the plaintiff has somehow waited too long in asserting his or her rights and therefore has lost the right to bring this action. That's an affirmative defense that must be filed by the defendant or forever lost. There are other affirmative defenses that must be raised by the defendant. Laches is an affirmative defense. Estoppel is an affirmative defense. Res judicata and collateral estoppel, items we addressed in Section 2, are affirmative defenses that must be raised by the defendant. Laches is a delay in asserting your rights that has caused prejudice to the other side. Estoppel is a defense that suggests that somehow the plaintiff should be punished, or at least denied their rights to bring this suit because of some actions that they have brought previously that should limit their right to bring this action. If, for whatever reason, a plaintiff chooses to amend their complaint, under Rule 15, they are generally given wide latitude in amending their pleadings if there's been some defect that has existed or that the plaintiff chooses to file an amended complaint under Rule 15. Perhaps the capacity under Rule 9 or form under Rule 10 is somehow defective or at least not clear to the other side. Then an amendment under Rule 15 could be proper. Most important requirement to remember within the early part of the rules and with respect to any period of the litigation is the plaintiff's obligations under Rule 11. Rule 11 is a good faith requirement in signing pleadings that requires every attorney, plaintiff's attorneys or defendant's attorneys, to make an acknowledgement by affixing their signature on the pleading, that they are suggesting or affirming to the court that that pleading is based on good faith, not interposed for any improper purpose, such as delay or harassment of the like, and that it's based on existing law or a good faith belief in reversal of existing law. Rule 11 requires attorneys to act honorably, to act diligently in making representations to the court, and it allows the court to impose significant sanctions on attorneys should they choose to violate Rule 11. Rule 11, either under the federal or state system, is enforced stringently and requires attorneys to act not just in good faith, but with the highest level of integrity. Lastly, in this section, we're dealing with counterclaims and cross-claims. One of the other things that a defendant can do in response to an initial pleading. Defendant, as we said, could choose to try and move to dismiss, can choose to answer, and in some cases will choose to assert a counterclaim or a cross-claim. Counterclaims can either be compulsory or permissible. A compulsory counterclaim is considered one that arises from the same set of facts or circumstances as the principal claim. What that means is that whether there's been a course of dealing between the plaintiff and the defendant now is saying, well, not only don't I owe you the $10,000 you claim, but you owe me money as a result of add-ons to the contract or your inability to ship the product timely. But somehow the defendant has a cause of action against the plaintiff, and it's a compulsory counterclaim if it arises from the very same set of facts, or a permissive counterclaim when it doesn't arise from the very same controversy that embodies the plaintiff's complaint. Sometimes you'll have plaintiff and defendant who have a course of dealings over a number of years and a number of different dealings. And then you could have either compulsory counterclaims that relate to the initial complaint or deal with other business matters between the two parties. Those would be permissive counterclaims. Lastly, you could have cross-claims asserted by one defendant against another defendant. And this may happen in claims of indemnification or claims where we've got joint tortfeasors or joint defendants and one defendant saying, not only isn't it my fault, but if I owe the plaintiff anything, then this defendant, the third defendant, should compensate me for anything I may be out of pocket on this. So counterclaims and cross-claims allow defendants to assert claims against individuals in the lawsuit. Counterclaims.
In civil suits, much of a lawyer and a litigant's time is spent on discovery. Discovery is the exchange of information that will help to prove a party's case or a party's defense. And there are formal rules with respect to discovery, and they are found in Rules 26 through 37 of the Federal Rules of Civil Procedure. Rule 26 requires that there be voluntary disclosures of information by each side prior to the start of formal discovery. These voluntary disclosures require each side to provide the other with the names of likely witnesses, sources of potential evidence, location where that evidence is likely found, and even the value of the case and the potential settlement value of the case. The idea behind the voluntary disclosures is to provide means for each party to assess their case relatively early, to make a determination as to the strength and weaknesses of the case, and also the monetary value of that case, with an understanding that perhaps the parties will engage in an early attempt to resolve it by themselves or through alternative dispute resolution and the like. And hopefully what that will allow the parties to be able to do is to not engage in the type of paper war that we see oftentimes civil litigation fall into, and so that parties spend a fortune simply trying to obtain the information that, if it had been voluntarily given, parties would have been able to make a relatively early assessment of the case and decide whether it makes sense to continue to engage in this war or to try and sit down and be reasonable with respect to potential resolutions of the matter. Until the voluntary disclosures under Rule 26 take place, there can be no formal request for discovery. So it's important that those disclosures be done relatively quickly at the start of the case. Beyond that, all of the rules of discovery are found in Rules 26 through 37. And so it goes from the very start of what you would be entitled to receive under the scope of discovery all the way through sanctions. And the scope of discovery has been changed in recent years. The federal courts have chosen to limit the scope of discovery from its historical place, and have now decided that parties may obtain discovery regarding any non-privileged matter that is relevant to any party's claim of defense. And the new key is language that they've added that says, and proportional to the needs of the case, considering the amount in controversy, the importance of the issues at stake in the action, the party's resources, the importance of the discovery in resolving the issues, and whether the burden or expense of the proposed discovery outweighs its likely benefit. Information within this scope of discovery need not be admissible as evidence in order to be discoverable. And that simply means is that not everything you will obtain throughout discovery is ultimately going to meet the tests of the strictures of the rules of evidence. But that doesn't mean that you're not entitled to review it, to access the information, and then make a determination as to whether you will be able to use it at trial or not. So to put it simply, the scope of discovery under the modern rules is anything that is non-privileged, that is relevant to a party's claim or defense, and is proportional to the case itself. And it's the last part that really now poses somewhat of a problem. Proportional to the case, when we start to consider what the needs of the parties are, what the likely resources of the parties are, what the value of the case, and the value of the case is oftentimes going to be a subjective matter depending on that party's personal stake in the case, how important it is from their perspective. But the court has to assess the importance on a general basis, and a lot of cases to anyone other than the litigants has really very little importance. And so this gives the court some ability to restrict what historically has been accessible through discovery. And again, the concern about discovery is that it can be very expensive, but the understanding is that if we are attempting to search for the truth, then at times that can be an expensive process. The modern rule, this change that is now in effect, requires then the court to take a further look at discovery requests to make sure that it is in fact the extent of the request and the cost of compliance with that request is going to be proportional to the case itself. And so does that mean small cases get a smaller scope of discovery and bigger cases get a bigger scope of discovery? That very well may be true. Also is going to likely be true depending on the financial resources that each party brings to the table. So it's a significant change, and we're going to see the court likely place restrictions on discovery going forward, so that it at least becomes, to some extent, more economically reasonable to go forward. The question is will it produce sufficient results that it won't affect the administration of justice and a party's access to that justice and the proof they need? When we say that evidence is relevant to a claim or defense, all we're saying is that it would tend to help prove or disprove a fact of consequence to the case. So the scope of discovery, if we read the words literally, is still pretty extensive. It doesn't mean that it must prove or that it proves beyond a reasonable doubt. All it has to do is tend to help prove or disprove a fact of consequence to fall within the scope of discovery. And under those circumstances, then, if the request and if the cost of compliance is proportional to the case itself, then you will be able to have access to that information. And the parties then would have to provide that information to the other, provided that it is non-privileged information. Now, in a civil case generally, we have a number of different forms of discovery, and we oftentimes would start with what are called interrogatories under Rule 33. Interrogatories are written questions to the other side, requiring them to answer under oath certain questions that are going to produce discoverable information. These are devices that are limited to parties only. They oftentimes are not going to gather complete information or completely honest information. And by that, what I mean is fully forthcoming more than anything else, because you have a number of days to respond to those interrogatories. You're obviously going to consult with your attorney throughout that process. And in fact, the attorney is going to draft the answers to the interrogatories based on your conversations, and then be available for advice as you look over those final interrogatories and then sign them under oath. The problem is there's no immediate feedback, give and take, like you would find at a deposition. And instead of being fully forthcoming, those answers could be guarded. What it helps to do is fix a party's position on certain issues such that you have an answer under oath. So if the question is properly framed, you can start to confine them to certain positions that could be helpful as other means of discovery go forward. Rule 33 are interrogatories. They are required or permissible to use only for parties. Rule 34, again, parties only, request for production of documents and things. Oftentimes a second step in much of discovery. What we do is we are accessing or attempting to access information in the other party's hands. These are oftentimes documents. It can be other things as well, physical evidence that the party may have. And they are a series of requests for information that the other side then must respond to, either by making copies of that information available or by making access to that information available in the manner in which it's regularly maintained. And then it's my job to figure out what data I want to take and in what form I want to use it. Obviously, we can use technology now to preserve much of that information in a much easier fashion than has been previously done. And so it may make more sense to produce that information electronically or to at least store it electronically for ease of access down the road. But requests under Rule 34 oftentimes are the second stage in that process. And we're going to talk at the end of this about special problems related to ESI, electronically stored information, and how we're going to access that under a request pursuant to Rule 34, cognizant of the fact that the court can limit my discovery to what is proportional to the case itself. So oftentimes when we start to think about retrieval of electronically stored information, depending on how it's stored, that can be a relatively easy process to produce the information in some data form, or it could be a relatively expensive process just to search for the information in various drives and storage devices as well. But Rule 34 requires if a party serves it on the other side, to respond in a timely manner so that that information is then obtainable for review for discovery. Rule 35 a request for physical or mental exams of a party. When that physical or mental condition of a party is an issue in the case, I can request from the court to be able to undertake that physical or mental exam. And obviously, both can be relatively intrusive, and we do argue about how the scope of that exam, who is qualified to conduct it, but obviously it's the adversary's choice, oftentimes approved by the court, and the question of how intrusive and how many personnel can be involved is oftentimes debated, certainly discussed, and sometimes court intervention is sought to ensure that it doesn't go on too long or doesn't involve too many experts. Again, part of the concern here is that we're producing information that if the physical and mental exam is an issue, there will likely be testimony at trial on it, likely expert testimony, and you do want to be careful as to how much of that information is then created. When your adversary seeks it, it isn't likely to be helpful to you, so that is oftentimes a debated request, and court intervention oftentimes is used to control how much of that physical or mental exam takes place and over how many days and how many people are going to be able to be involved in it. Rule 36 are requests for admissions, and requests for admissions are simple statements of fact that require then the other side to either admit or deny. It doesn't require and it isn't able to use a narrative answer. The other side simply has to respond by either admitting or denying the fact. To the extent that that fact is denied and the court later finds that it reasonably should have been admitted and there were costs required by an expert to introduce testimony on that issue, the court can assess the costs against the party who denied the request for admission if the court finds that that information should have been reasonably admitted. For instance, if the value of a commercial building at 1 Main Street is in dispute in the case, one side sends a request to the other side that the value of the building at 1 Main Street is worth $10 million, and the defendant who received the request denies that request for admission, and the plaintiff is then put to its proof in having to produce an expert, have an appraisal done, and the expert then testifies at trial that the value of the building at 1 Main Street was $15 million, then under those circumstances, if the court determines that that testimony is credible, the court would then determine that the defendant should have reasonably admitted that the value was 10 or more, and under those circumstances, the court has the ability to assess the value of the cost of the appraiser and the appraisal at the expense of the defendant if the testimony indicates that the value reasonably was that $10 million figure. So requests for admissions can help shift some of the cost of the production of that evidence at trial, and that is an important part of it. Requests for admissions are used pretty far down the road as we get closer to trial and want to look to eliminate some of the time of trial and the cost of production of the proof. The most common form of discovery in civil cases is Rule 30, which are depositions. Depositions are where we bring a party or a witness, and this is one of the means of discovery that can be used with any individual, where they are brought into the office, they are sworn, and then they answer questions under oath, and then the other side or other parties have the ability to ask them questions as well. The most common form of deposition is a stenographic means. They can also be audio-visual depositions, or they can simply be audio. An audio deposition doesn't have the same value either from the standpoint of persuasiveness at trial or convenience of use. from the standpoint of you probably likely still have to have it transcribed in order to be able to have some value using it at trial. Where an AV deposition has both the visual pictures of the witness testifying. Oftentimes, you would then have a stenographic record of it made as well, and it can be a very persuasive means of producing that testimony from what would have been an unavailable witness, such that their depositions would have had to be read into evidence. The problem is an AV deposition is significantly more expensive than a traditional deposition where the witness is sworn under oath and a stenographer records everything that takes place, every statement that's made during the course of the deposition. And the value of depositions are then as we have the witness's story under oath. If they testify at trial, we can then use their prior inconsistent statements to impeach them. And if they do not show up at trial, then we have the ability potentially to use their depositions as what we call former testimony. It's a way of avoiding surprises at trial, obviously, but it's also a way of obtaining the information and is probably as truthful of a version as you're likely to hear, simply because you have the ability to immediately follow up a question with another question. You have the opportunity to observe the witness as they're testifying, and you have some ability to assess both the credibility of the witness and their likely ability to persuade the jury with respect to what they're saying. And so it's a good device both for gathering information and assessing the strength of the case at trial. And so we use depositions often. Some courts have taken to limiting the number of depositions in civil cases, and the part of the reason for that is that, again, this is a process that even in a small case, you could have a number of depositions, and depositions can become very costly in order to gather the information appropriately. If we are doing a deposition of a non-party, then under those circumstances, the way in which you bring them to the office in order to testify, and if you want them while they're coming to bring information, is through a subpoena ducas tecum under Rule 45, coupled with a notice of deposition that is then served on the individual, and they then come into the office. They're commanded under the subpoena to come in the office, and the subpoena can also require them to bring certain information so that you both have the ability to access documents and things that they have in their possession, as well as then gather their testimony, both related to the case, as well as that might be what we would call foundational for those documents and things that you requested that they bring. And so once it is, in fact, recorded stenographically, and if it's a witness other than a party, we have served them with a subpoena for that information. They then are deposed, and if we had some feeling that that witness would not appear at trial, and we think that they could be their testimony could be conveyed effectively by audio video deposition, then we would likely spend the additional funds to have that witness testimony recorded by audio video deposition, such that the jury would have a better understanding of the testimony, and perhaps it would be more persuasive. The asbestosis cases were lost by the plaintiffs until the plaintiffs started to audio video the depositions of the plaintiffs. The reason for that is that oftentimes, because the defendant would delay the case, the plaintiffs who were suffering from the asbestosis would not survive until the time of trial, and so the jury never saw the suffering that the individual was going through, or really couldn't be effectively conveyed to them. And where the evidence was relatively close, the jury sided with the defendants. When those depositions of the plaintiffs started to be recorded by audio-video means, and then that testimony was presented in that form to the jury at trial, since the plaintiffs now were dead by the time of trial. The jury now had a much fuller understanding of the scope of the problem and the pain and the suffering that the plaintiffs endured as a result of being exposed to the asbestos. And at that point, those jury verdicts changed from predominantly defendants' verdicts to the plaintiffs' verdicts. And if you think of that example, there are a number of different situations where you would then start to think as a tactical matter while you're doing discovery, is this a really important witness that A, isn't likely to survive until trial, and B, whose information would best be conveyed electronically by way of their testifying in court on a television monitor, as opposed to a pretty dry presentation by the attorneys reading the depositions. And again, when you start to think about it, in this electronic age, that we tend to look at those images and they can be significantly more powerful than a witness simply testifying on the stand, and it certainly can be a lot more powerful than some lawyer or lawyer's assistant reading a months or years old deposition of a witness. Question, answer, It's a pretty dry presentation done under those circumstances. So what happens if you don't comply with discovery? And that gets us to Rule 37. Rule 37 allows the court to provide sanctions for parties who fail to comply with discovery requests. So if a legitimate discovery request is provided to the other side, and the other side doesn't object timely to it, but simply doesn't respond, or objects, and then that question has to be argued before the court. We either can bring a motion to compel discovery. Oftentimes, courts require us to confer to try and figure out why we're not complying first. But at some point, we're going to need the court's intervention to force compliance with that discovery request. Defendants will always argue that it's unduly burdensome, or the other side, plaintiffs and defendants, will argue it's unduly burdensome. No one wants to go through their files, gather all the information that the other side wants, because from a business standpoint, it can be costly. From an individual standpoint, it can be costly. And it's not something I want, it's something the other side wants from me, so why should I give them anything? There's a million different arguments and reasons why people don't want to comply with legitimate discovery requests. And the other side of that is not every discovery request is legitimate. But the bottom line is the court has the ability to regulate that scope of discovery, especially under Rule 26 now, where it can look and see whether the discovery request and the cost of its compliance are proportional to the case itself. And so this becomes another area where the litigants would likely want to test the court to see how much is too much and how little is enough, that we're likely to see the court get more involved with respect to policing these discovery requests, either by way of the motions to compel or the sanctions that are requested under Rule 37. And so once the motion to compel is filed, oftentimes if the request is overbroad, the court may restrict it to some extent. And if the request is not overbroad, then the court is going to order the other side to comply within a relatively brief period of time. Any party who continues to not comply with those legitimate discovery requests, once the court has examined that question of non-compliance, then the party risks sanctions under Rule 37. As we saw in the Insurance Corp of Ireland case, the court sanctioned the defendant for failing to cooperate in discovery, and as a sanction precluded that party from contesting any longer the question about whether it was subject to the court's exercise of personal jurisdiction in Pennsylvania, because their dilatory actions, the efforts they took to evade compliance with the party's request, and then the court's modified order, and then at the last minute to suggest that they had 4 million documents that were responsive to the discovery request, but they were located in a warehouse in London, wasn't fair to the plaintiff, wasn't appropriate to do with respect to the court's orders on the motion to compel, and at some point the court's patience grew thin, and the court decided that they weren't legitimately contesting the issue. They were simply trying to be dilatory and evade compliance with the legitimate discovery requests, and therefore, as a sanction, precluded them from trying certain issues in the case. In this case, it was personal jurisdiction. The court has the power to do that under Rule 37. They can sanction you monetarily. They could try to coerce compliance by saying $1,000 a day until the documents are produced. They can, as they did here, preclude you from trying certain issues in the case. And it's not just procedural issues. Sometimes they will strike your defenses as part of the sanction. Sometimes they will limit the plaintiff from producing proof on a certain issue and strike that issue from the case as a sanction. They can even, and we've seen this, we saw this in Whitney Houston's daughter's litigation, they can even sanction you for non-compliance with the discovery request, including you lose, in essence, then by default. Because you failed to comply with the discovery request, you no longer can contest anything, and therefore judgment is going to be for the party who was seeking that information and against the party who refused to cooperate with the discovery requests and the court's orders, and now is lost their case because it's a sanction against them for failure to comply. So the sanctions for failure to comply with discovery, as we see, can be quite significant. And again, it's our job to encourage our clients both to preserve evidence, to preserve information once it's likely that litigation will follow or where litigation has been threatened, and B, to then, in a timely manner, produce that information so that the parties can exchange what would be potentially needed at trial because it's relevant, because it helps prove or disprove a fact of consequence to the suit, and it isn't otherwise privileged. Now, with respect to privilege information, if documents are subject to a claim of privilege, generally attorney-client privilege, work product privilege, sometimes Fifth Amendment privilege, which can be claimed in a civil case, sometimes it'll be spousal privilege, whatever privilege might attach to the documents or other things that are attempting to be held back through discovery, there should be what we call a privilege log produced. Let's talk briefly about e-discovery, because it's much more likely now, instead of being found in some old file folder full of dust somewhere, that it's likely found on a person's laptop or computer or their smartphone with respect to the proof that we need that would be within the scope of discovery. So when we're talking about electronically stored information, the rules of discovery still apply, obviously, but the format of the material is slightly different. And this becomes a key item of dispute these days as to how do we access someone's smartphone, their laptop, their personal computer. How do we get them to really do a thorough search of those devices so that we obtain the information? And if it's just not, individuals or small businesses, what happens when we're looking at suing a Fidelity or a Microsoft or companies like that, where so much of the information is electronically stored and maybe stored in older storage devices such that the search itself can become incredibly time-consuming and at least argue that it's incredibly expensive. Having been involved in both, I would argue that e-discovery, frankly, is oftentimes significantly less expensive than the old form of paper production that we saw and that we engaged in for many years. I've had cases where we've had nearly 1 million documents produced on paper. And I've also had cases where the entirety of the production was on a single DVD drive. And that included both multimedia productions as well as emails and other documentary evidence, even manuals from the company that were thousands and thousands of pages. The fact is that whatever format it still falls within the scope of Rule 26. But when we talk about ESI, or electronically stored information, the seminal case really was Zubilaki. And so Zubilaki produced a new 7-step test with respect to electronically stored information. And that test, the court said we should be looking at, or the trial judge should be looking at, is really, again, what we now see embodied in the new rule about proportionality. And that is the key going forward. And I think these 7 factors look at that proportionality argument. The first factor is the extent to which the request is specifically tailored to discover relevant information. 1, the extent to which the request is specifically tailored to discover relevant information. This isn't just casting a wide net. The court's asking, is this just an omnibus request for virtually everything and anything in the world, or is this really likely to produce relevant information here? And if it is, then under the circumstances, it should be honored. To the extent it's an omnibus request that we can narrow and tailor so that it will produce relevant information, then perhaps we should do that. 2, the second factor, the availability of such information from other sources. Are there other means to access this information? And if so, have we looked at those other means? Have we tried to? Can we try to? And is it likely cheaper to be able to obtain it in some other fashion? 3, the total cost of production compared to the amount in controversy. Again, this is proportionality before proportionality was embodied in the rule. But it really says is, okay, what is the cost of production and how valuable is this case anyway? Again, smaller case, likely smaller scope of discovery. Bigger case, likely bigger scope of discovery. Understand that the fight will be the same in both cases. 4, the total cost of production compared to the resources available to each party. And again, this is the relative value of the case with respect to now their assets. What are the resources? Poor plaintiff doesn't have many resources. Rich defendant does. And so how should we weigh the cost that are required here to the relative resources of the parties? Again, to some extent, it's proportionality raising its head in Zubilaki as a precursor to what we now see within the rules. 5, the relative ability of each party to control costs and its incentive to do so. And this is an interesting factor because oftentimes in discovery and up to Zubilaki, no one thought about, really trying to control the cost of discovery and to really make it efficient, but still make the information accessible. And so where are there incentives to do things on a reasonably cost-effective basis? And so it's an interesting factor. And it's important, as the court now sees it, when we start to talk about what can be a very time-consuming and expensive process searching for electronically stored information. The importance of the issues at stake in the litigation. And again, now we see this embodied in the Act, the rules as well. But the importance of the issues at stake in this litigation and the importance of the issues at stake really are oftentimes pretty subjective. view, at least taken by the litigants. Of course, the court is supposed to be looking at those interests objectively. It's an interesting question in going forward, whether, an individual who has been discriminated against at work and has lost their job and now potentially going to lose their house and their family is significantly at risk here. The importance to that plaintiff couldn't be understated. And to the court, it's just another plaintiff seeking its damages in court. Court may not see it as the same as the individual plaintiff, certainly wouldn't. And the defendant, and this may well be a defendant who's just another case where they have been charged with doing something wrong and intends to defend it to the end. I don't know how a court can look at, I don't know how judges will look at that and value it the same when we start to think about what the relative interests are to the parties and the way they would see the importance. To the defendant, it may just be another bump in the road towards their long progress of defending these claims, and to the plaintiff, it likely couldn't be a more important step in the road to be able to access the proof that they need. And 7, the relative benefits to the parties in obtaining the information. What are we likely to get here, and how strong will it likely be? Zubilaki really lays out the precursor to the proportionality that's now found within the rules, specifically rules 26 through 37.
Now, we earlier talked about motions to dismiss, which really test the early part of the pleadings, the complaint in essence itself, as well as motions to dismiss because of improper service or venue or other matters. And motions to dismiss test the complaint in essence. Motions for summary judgment test the sufficiency of the pleadings taken as a whole. And what they ask is, are there material facts in dispute that rise to a triable level such that we should deny the motion to dismiss if there are material facts in dispute, or grant the motion for summary judgment if there are no material facts in dispute. Juries hear questions of fact, judges determine questions of law. Juries determine questions of fact, judges determine questions of law. If there are no material facts in dispute, then the judge should in fact interpret the law and grant summary judgment. We don't have a need for a trial in this case. If you remember the cases in the summary judgment line of sequence, the Dickey's versus Crest case, where the court said, what material facts are there in dispute? What would preclude the grant of summary judgment? The Anderson versus Liberty Lobby, the last line in that last case in that sequence, and then the middle case in that sequence was Celotex versus Cataract, which said it's not enough to sit back and dispute the evidence. What do you have in an affidavit form or otherwise that'll tell us that there are material facts in dispute? Is there some evidence you have to support the allegations you're asserting that you should have the right to a jury trial? Anderson versus Liberty Lobby, which was the last line as we saw that the law developed there, said not only should the court make sure that there are material facts in dispute, that there's some evidence to support that dispute, but the court also, under Anderson versus Liberty Lobby, must weigh the evidence and take a look at and try and determine, is this truly a case that is jury worthy? Now, many people would argue that this continues the erosion of the right to a jury trial, and frankly, rightly so. But this is where we're at under the federal system now. After those 3 cases, the standard is that do we have material facts in dispute that rise to a triable level? Are there material facts in dispute, not just contested, but supported somehow, that rise to a triable level. And by rising to a triable level, we only mean consider the burden of proof that the plaintiff has. If it's a more likely than not case, the preponderance of the evidence case, that's kind of an easy threshold for a plaintiff to make. But in Anderson versus Liberty Lobby, it was a clear and convincing evidence case, and that's a pretty high threshold for a plaintiff to make. The court reasoned that the plaintiff, in fact, could not make that threshold and therefore granted summary judgment. Juries aren't needed if there aren't questions of fact in dispute. Judges then determine questions of law. Summary judgment is a testing device that tests the sufficiency of the pleadings taken as a whole at that point, and which can preclude the plaintiff's ability to have a jury trial on that case. This concludes our section. Section 5 deals with trials. In any civil case, it is the plaintiff's burden to prove both liability and damages. It's not enough to show liability, but not be able to show any type of loss as a result of the defendant's actions. Plaintiffs have to show at trial both liability and damages. And they must show it either to a judge or to a jury, and that will depend on, as we talked about in Section 1, whether the plaintiff has demanded a jury trial right under Rule 38. If a plaintiff has demanded a jury trial, then at this point in time, the plaintiff will present their proof both to a judge and a jury who will resolve the case. But the plaintiff has to show liability and damages. Most civil cases use the preponderance of the evidence standard. And all that means is that the plaintiff must show more likely than not what they're saying is true. More likely than not. And that means what? 50 plus a little, or 51% to 49%. The plaintiff's version of the events is more likely not than not. Tip the scales ever so slightly in the plaintiff's favor is the general civil standard, preponderance of the evidence. The other civil standard that's used is clear and convincing evidence. And it's much harder to define exactly where that falls on our scale. Is it 75%, 85%? The courts have not been clear as to where that falls, but it's somewhere in the much higher range. Some liken it to it's a civil beyond a reasonable doubt standard, which would put it obviously much higher than even we've talked about. But a clear and convincing evidentiary burden requires the plaintiff to prove something to a much greater degree. Malice, for instance, has to be proved generally to a clear and convincing evidentiary standard. It puts the plaintiff to a higher evidentiary burden. The last standard of proof of these three that we talk about is beyond a reasonable doubt. And as you know, that's the general criminal standard. Beyond a reasonable doubt, you would find the defendant guilty. These are the standards of proof. Preponderance of the evidence, the general civil standard, clear and convincing evidence, the intermediate civil standard, or the highest civil standard, but the intermediate standard of proof, and beyond a reasonable doubt. The plaintiff bears the burden of proof in a civil case. It is the plaintiff's obligation to satisfy that evidentiary burden. The plaintiff is aided somewhat in this process of persuading the jury with the assistance of the judge in jury instructions under Rule 51, which require the court to instruct the jury as to what the law is. We've given them all the facts, we've introduced them to various documents that should aid them, and at some point the court has to instruct them and tell them, in considering all the facts, this is what the law says. The law, for instance, says that you need to show duty, harm, duty, breach, harm, and causation in a negligence action. The judge has to instruct the jury on that. And good lawyers prepare their documents so that they can assist the court in instructing the jury and request certain instructions and object if those instructions are not given so that they can preserve that matter for appeal. Under Rule 48, you need a unanimous jury or a majority if you could agree otherwise. So it's up to the plaintiff and the defendant to come to an agreement, and absent any agreement as to the whether a unanimous jury is required or not, a unanimous jury is in fact required in order to find for the plaintiff. In Massachusetts, there's a statute that says you only need 5/6 or better in a civil action. Under Rule 49, you could submit jury interrogatories or requests for special verdicts to the jury in order to aid both their understanding and resolution of the case. In essence, the jury interrogatories are questions that go down and help the jury arrive at the decision in the case by taking them sequentially through each field that they would have to resolve. Under Rule 49, a plaintiff can request, or a defendant can request, special verdicts or jury interrogatories in order to help them resolve that case. Under Rule 50, both the plaintiff and the defendant have the right to test the sufficiency of the proof introduced at trial. Rule 50 allows the plaintiff or defendant to say that a reasonable jury on the basis of this evidence could not find for either the plaintiff or the defendant. Prior to a change in the rule, it was called a directed verdict if the verdict was filed, if the motion was filed pre-jury deliberation, and it was called a motion for a judgment notwithstanding the verdict if it was filed after the jury came back.
This is Section 6 of the presentation for civil procedure and remedies, and it deals with choice of law issues, or conflict of law issues as it's commonly referred to as well. This section will cover issues involving the federal courts and their use of federal law, state law, the federal rules of procedure, and how some of these conflicts are resolved in the federal court when parties are contesting which is the appropriate law to use. These questions oftentimes come when there is a question about does federal law control, or what happens when a federal court exercising diversity jurisdiction or supplemental jurisdiction is faced with challenges as to which law should provide the substantive law that ultimately will be used to resolve this matter. As a general matter, when a federal court is hearing cases with the subject matter jurisdiction based on a violation of federal law, federal question jurisdiction, as we commonly refer to it as, then a federal court resolving issues of federal law uses federal law to resolve those issues. A federal court will also use the federal rules of civil procedure to resolve any issues that have come up with respect to how service of process should be made, what's the standard for summary judgment and the like. But a federal court is always going to use the federal rules of civil procedure, whether it is hearing a question based on federal law, constitutional law, or a diversity case. Diversity jurisdiction is where we see particularly cases that develop with respect to what law should apply. Choice of law issues, these conflict of law issues, oftentimes happen when that state law case is being tried in federal court and the parties dispute which law ultimately controls the outcome of the case. Remember, when we look at a diversity jurisdiction case, that when a federal court is exercising diversity jurisdiction or supplemental jurisdiction over state law claims that are pled along with the federal court, the federal court uses state substantive law to resolve those claims. A diversity suit is nothing more than a state lawsuit that gets to be filed in federal court because of the citizenship of the parties and the size of the claim. It doesn't convert them to a federal claim or a federal question simply because those claims are filed in federal court. In a diversity suit, the court will use state law to resolve that controversy, and it will be the first state that acquires subject matter jurisdiction, personal jurisdiction, and venue over that claim in attempting to resolve any choice of law issues that are raised. Diversity jurisdiction, remember, at its core is involving controversies that involve state law. Subject matter jurisdiction isn't predicated upon anything other than the diversity of citizenship between the defendants and the plaintiffs, and the plaintiff is alleging that the claim is likely to exceed $75,000. No plaintiff can be from the same state as any defendant, and the claim must be reasonably likely to exceed $75,000. For the purposes of diversity jurisdiction, an individual is considered domiciled where their true, fixed, and permanent place of residence is, and a corporation is considered domiciled in their state of incorporation and principal place of business. Once we know we have a diversity jurisdiction matter, then the question becomes, well, what law applies? And since a federal court sitting in diversity is nothing more than an extension of the state court system hearing that matter, the federal court will use state substantive law to resolve that controversy. That's the teachings of Erie. The outcome of that matter, that federal court matter that is being heard on the basis of diversity jurisdiction, while using state law, also should have the same outcome as it would if a state court was hearing that very same matter. This is called the outcome determinative test, and it came to us from Guarantee Trust versus York. In essence, the federal court, when it sits in diversity, is just another location to try a state law case, and therefore you use state law, and the outcome shouldn't be any different than it would be had the state court been hearing that same matter. The outcome determinative test is important that in diversity suits and claims involving supplemental jurisdiction, that the result be the same as it would have been in the state court hearing that same matter, because that's the teachings of Erie. Erie, as you will remember, overruled the long decades use of Swift versus Tyson was an improper power grab by federal judges. There was no authority for the use of the federal general common law that was created by judges for decades. Diversity suits use state law suits, and the outcome should be the same as a federal court resolving that same matter. However, there are two major exceptions to the outcome determinative test. The outcome determinative test can be violated if there's an important federal right at stake, such as the right to a jury trial, as we saw in Byrd versus Blue Ridge, or if there's a federal rule of civil procedure directly on point that controls the question. And we saw that in Hanna versus Plummer, which was the service of process issue on a diversity suit. Are we authorized in federal court to use the federal rules of civil procedure on a diversity suit, even where the use of that rule would vary the outcome of the case, in fact, change the outcome of the case 180 degrees. The federal court said in answer to both questions, our Supreme Court said, A, if there's an important federal right at stake, such as the right to a jury trial, then because of the constitutional significance of that right, the federal courts are empowered to have those issues controlled by the U.S. Constitution. And the second half of that question is, if the federal rules of civil procedure govern the situation in federal court on a diversity suit, even if it would vary the outcome of the case, then the federal court is authorized under the Rules Enabling Act to use the federal rules of civil procedure. So what we have by the time we're done here is a sequence of cases that clearly spell out the problems that Swift versus Tyson allowed to perpetuate for decades, and following Erie give us a workable framework to resolve. The fact is, the Supreme Court doesn't, at the end of the day, get into as much is this procedure or substance, but what they do is give us a different set of rules to resolve these issues without facing that more difficult challenge, because procedure and substance, procedural law and substantive law, oftentimes are intertwined. It's very difficult to separate one from the other. Instead, what the court has done for us is provide a working framework for resolving these issues. Any choice of law analysis requires the federal court to start the analysis of which law to use by using the law of the state that first acquired subject matter jurisdiction, personal jurisdiction, and venue over the claims. This will oftentimes be the court that we are physically located in, but in the event of a transfer, you have to go back to the first court, their state law in that jurisdiction that first acquired jurisdiction, subject matter jurisdiction, personal jurisdiction, and venue over the claim. And even on a transfer between one federal court and another, that original state's law will follow the controversy to the new state. You then utilize, whether there's been no transfer and we're in the same court we were always in, or there's been a transfer, so we're using the transferor forum rules, the initial court, you use their state's conflict of law or choice of law rules to figure out what factors they look at in trying to determine whether the appropriate law is one state as opposed to another. And then lastly, that's what you're doing by looking at those factors with respect to their conflict of law analysis contained within the state law rules, is you're determining which law, at the end of the day, will provide the substantive law on liability and the various potential defenses that is needed to resolve the case. What law ultimately determines liability or no liability? And we use that law, that state's law, ultimately at the end of the day in a diversity suit. Even if it's easier to use some other body of law, like they did in Swift versus Tyson, we now know that a diversity suit only deals with state law claims, and therefore state law is going to be utilized to resolve that controversy. And that's the teaching of Erie Railroad versus Tompkins, that when you're resolving these complex, at times, diversity, jurisdiction, choice of law issues, make it simple. The simple part is that a diversity suit is a state law suit, and therefore we're going to use state law. We know where we begin. We begin with the first state that acquired SPV over the controversy, but oftentimes that analysis is only going to be done after the extensive amounts of research and time in trying to compare the various states that potentially are involved with the dispute, and at the end of the day, which one the court is likely to choose with respect to the choice of law issues. It's why, frankly, we see in a lot of these cases now, and a lot of contracts, that parties have agreed in advance what law will control any disputes they have. It's certainly, an ounce of prevention is worth a pound of cure. It's a lot easier to anticipate these problems at the outset, agree as to what law will be employed if there's a controversy, then wait till a controversy develops and then spend tens of thousands of dollars in trying to determine which law should provide the outcome of whether liability exists or not. You know, and states can pick and choose which factors are important to them. That's why it becomes a complicated issue. For example, Massachusetts, our choice of law rules express a strong preference for the situs of where the controversy took place as being very important in resolving the appropriate state law. We see the location of the accident, the location of the injury as being a very important factor as one looks at what factors to determine where suit should be filed. Remember, a federal court sitting in diversity or exercising supplemental jurisdiction is nothing more than an extension of the state court system. State substantive law must be used to resolve that controversy, and the result